When there's an injustice against you or someone you love or someone you believe in, stand up. Don't sit down on them, if they need you.
Hey up everyone, it's me, Steph the Alternate, your nerdy alternative. Apologies for the beginning. I pressed the wrong button and it started off with my tune over PopcornedPlanet, like, visuals. Yeah, it's been a long day, guys, but how are you all doing? Hope you're all doing well. Welcome to Popcorn Justice Live for Thursday, and I am joined with, yes, Christopher Melcher. Hello, hon. How are you doing this evening? Oh, it'll be the afternoon where you are, isn't it?
Yeah, I'm Los Angeles midday, lunch hour. So yeah, doing good. Happy to be here with everyone.
I'll never ever get used to these time zones, I swear, guys. But yes, it is still a Steph the Alternate takeover, so thank you to everyone that's tuned in so far, and thanks to all of your love that you've been giving to our earlier video. If you didn't catch it, go watch it after this live stream. We dig into the Kevin Spacey verdict, and Hollywood might be welcoming back with open arms. I just wonder, why won't they give the same energy to Johnny Depp? So we break it all down for you, so if you missed that video, do check it out. In the meantime, though, you may not have known there was a hearing yesterday for the Michael Jackson Corporation lawsuit versus Wade Robson and James Safechuck. Now, Chris, you watched it live, so before we jump into the little mini presentation that I've got, overall, what did you think to it?
Well, it's kind of anticlimactic because the Court of Appeal gave a very detailed tentative ruling that we got to see. And, usually when they go to the trouble of writing some multi-page document, it shows that they've given tremendous thought to it. And although they always say at the beginning of the hearing, we haven't made up our mind, they've made up their mind. So there was really probably nothing that the attorney here could do to change the outcome. It was inevitable. And we'll talk about what was going on. Why was it at the Court of Appeal? What was the issue? What does it mean? We'll get into all that. But in terms of yesterday, kind of went as expected because the court had already told us what it was planning on doing.
So generally speaking, when it comes to these kind of hearings and they go through the oral arguments, is it like 9 times out of 10 they've already made up their mind? They're just going through the motions, really? Is that what you're saying?
Well, yeah. So what we have in California is the trial court. So the Superior Court is where it takes evidence. So that's normally what you think about as a trial. You got somebody on a witness stand, you got a judge or a jury deciding the case. And then there is a intermediate appellate court, the California Court of Appeal. When things go wrong in the trial court and somebody complains, whether that's before the trial started or after, they can go to the appellate court and saying, hey, I need help and I want your inferior court, your lower court, to be reversed. So that's the posture of where this case was, is that they haven't got, Safechuck and Robson haven't got to trial. They haven't got to a jury. They got bounced by the Superior Court, saying that there was no legal duty owed by the two entities that Michael had formed that were being sued. So we're going to get into this detail, but basically pre-trial they got bounced on a ruling that there was no legal duty of care to these individuals, and therefore there was no case that could be brought. The plaintiffs brought that case up to the Court of Appeal and said, hey, there is a legal duty. We should be able to go forth. The Court of Appeal, they take their time. They look at it very carefully. They were going to review the case and the brief before they have oral argument. And so they created this tentative ruling saying, yes, there was a legal duty. And when they've taken the time to prepare all that, it's very clear that they have firmly held beliefs about how the case should turn out. Other times they literally haven't made up their mind and they're just like, hey, we need to hear from you to understand it. That didn't happen here. That we got that maybe a month ago or weeks ago, we got that tentative ruling. So that's why I say anticlimactic, no surprise. They just ended up, they haven't issued their ruling, but it was very clear from the expressions on their face, the statements that were made by these justices, that they were not persuaded to change their tentative opinion it's clear to me that they're going to adopt that ruling.
And there was a little bit of friction that we saw when we watched it. I watched it afterwards, as you guys know. It was a little bit busy for me yesterday, to say the least. But with that being said, let's crack into really the main takeaways from yesterday's hearing, because not a lot of people, I don't think, knew that this was being broadcast live. It was really, I suppose, only those in the know that knew about this link. I just happened upon the link by accident, in all honesty, guys. But here we go. So it starts off, the lawyer for the MJ corporations saying that, why are you essentially allowing Safechuck and Robson together in this case when previously they're actually at different junctions within the legal system? So with Safechuck, it was at what's called the demure judgment stage. So Chris, before we continue, in a nutshell, what does the demure judgment mean?
So yeah, this gets into some really technical stuff, okay? But to keep it real simple, we have, you know, cases that are brought. It starts with a complaint. So you know, you've heard anyone could get sued for anything. That's what a complaint is. Somebody types it up saying I've been wronged, and they file it. They get a case number. That's how you commence a case in California, Superior Court. Now, we have a strong preference for having trial on the merits. So when somebody says, hey, I've been wronged, we have a strong preference for allowing that case to get to a judge or a jury and be decided on the merits. But of course, there are times when the case is so weak that it should not go forth. The defendant or defendants should not be required to waste money on a lawyer or waste time of their life in defending it because it's clearly without merit. Now, the first way to bounce or to get that case dismissed is called a demur. Now, the demur is filed at the beginning of the case, and the defendants ask the court to assume everything in the complaint is true, and with that assumption, they say there's no case. So basically, hey, judge, take this at its worst. We obviously deny everything, but even if you assume that everything that this person typed in this complaint is true, it does not amount to a legal cause of action, meaning even if I did all these things, I can't be sued for it. That's what a demur is. That's what they filed. The two Michael Jackson entities filed in the Safechuck case, and the court agreed. And the court said that these two entities that were sued, because you have to also remember these particular cases are not against Michael individually or against Michael's estate. They're filed against two entities that Michael had created. I believe one was for holding rights and another was for touring or operations, something like that. So they sued the entities on the theory that the entities owed a legal duty to these two individuals to protect them based on their allegations of whatever they think happened, that these entities had a duty to protect them, didn't protect them, and therefore they were wrong. That's the case. So the Superior Court judge in Safechuck said, nah, I'm not buying that. Even if all the things happened exactly the way that Safechuck claimed, there's no duty, there's no legal requirement that the two entities had to protect Safechuck. And if they didn't have to protect him from Michael, then the case has to be thrown out. So that's Safechuck. Robson is a little bit different because that went further on in the case, and it went to what's called the summary judgment case stage. So summary judgment is later on in the proceedings where evidence is taken, and the defendants go to the Superior Court judge and saying, look, there's no dispute here over the key facts, or if we take these key facts as given, because there's no dispute. We have concrete evidence that certain things occurred, and because those certain things are true, therefore the case is, has no merit. Okay, so basically what they're stringing together or tried to string together in the Robson summary judgment motion is saying, look, we've taken depositions, we have evidence, we have declarations, not on all the facts, but just on the key facts about this duty issue. And based on the facts that we've developed on the duty issue, these two entities had no legal requirement to protect Robson. And the Superior Court judge agreed and tossed that out. So both cases are now coming up to the Court of Appeal, the higher court, on the same type of issue. Did these two entities have a legal duty to protect Safechuck and Robson under these circumstances that are alleged? If yes, then they have a right to go to trial. If no, then the case is properly dismissed. The Court of Appeal said, look, based on what we're seeing here, and again, they're not deciding the facts of the case. They're just saying, based on what's alleged, the circumstances here, there is a duty to protect them. And so we're going to let the case go forward to trial. And then it's for a jury to determine whether any of this underlying conduct occurred. And if it did occur, why the entities would have any ability or obligation to protect either of these individuals.
Mm. And from what I could gather at the beginning of this, I think the reason why the lawyer was pointing this out is to argue, why are you allowing both these men at the same legal juncture to carry on with this case jointly, where separately they're at different legal junctures. Safechuck was at the demurred judgment stage, where his allegations then weren't even tested within the court system, whether they're true or not, whereas Robson's were. So I kind of felt at that point that the lawyer was trying to argue on a technicality to try and get it like thrown out so that it doesn't proceed any further. Was I pretty much getting the right gist of that, Chris?
Yeah, I think that the argument is stronger for Robson because his case did proceed and, to the summary judgment phase where there was more evidence taken. But, again, ultimately, we have a strong preference for trial on the merits. And the issue of duty, duty of care, do you as an individual or do these companies have a duty to protect somebody else, is a pure question of law. And so they're either right or wrong about that. And this Court of Appeal is saying, look, on that very narrow question, did the two entities have a legal duty of protection to these two individuals? If the answer is yes, then they are allowed to go to a jury on whether that duty was breached. And there's a lot to be said about that because, again, the allegations that are being made to set up this duty argument are vehemently denied by the two entities in Michael's estate. So, for example, both these individuals were minors when the conduct allegedly occurred, and they're alleging that they were employed by Michael Jackson's entities. Michael Jackson's entities, I believe, deny that allegation. But again, that's for a jury to determine. It's not for this Court of Appeal. The issue is so narrow. And so the question is like, hey, if that allegation is true, does it create a duty of care from the employer to the employee? Well, of course it does. I mean, there is an obligation by employers to provide a safe workplace. So that's not even a question. So the question is, okay, was there an employee-employee relationship or contractor relationship with these two individuals such that there was, in fact, a duty? So that's the factual question that has to go to the jury. We can't just say, hey, we deny it, and therefore you don't get to go to a jury. That's not how it works. The jury decides disputed questions of fact.
So regardless that they were at different points, junctures within the legal system separately with their allegations, the simple question of, look, was there a care of duty between the companies of Michael Jackson and Robson and Safechuck, that overrides any legal technicality of, well, they were in different junctures of the legal system, so why are you treating them at the same time? Okay. Well, moving on to the next part then of this hearing, he went into a lot of detail, really, that he's basically saying there's no evidence. Now, he relied a lot on the Robson case because, again, that was the one that went to summary judgment and it went to, depositions, and there's a lot of evidence behind it. And so at the time, he's arguing, look, there's no evidence obtained that Michael Jackson Corporations assured his parents that he'd be well taken care of. No evidence that Robson's parents were instructed by corporate employees to only sleep in guest quarters. no evidence that he was allegedly, and this is for YouTube Human Reviewer, had things done to him in a recording studio owned and staffed by the MJ corporations, and every claim by witnesses are just allegations. They're not proof, as they haven't been proven. Now, I think this all goes back to what you were just saying like 2 seconds ago, which is, well, regardless, there's still a question of duty to be answered, that this is going to go to a jury in a trial no matter what. Even if you're going to turn around and say, look, there's no evidence, I think you're pretty much turning around and saying the judges are going to be like, no, let's take this to the jury for them to decide if there's no evidence. Would there be any scenario whereby the judges would actually turn around and say, yeah, there's no evidence, it's not going to go to trial?
No, this is not the way it works, and that's what I think is frustrating from viewers looking at this and saying like, well, hey, you know, we don't believe these two individuals. They've been discredited. You know, there's, you know, a whole history there of information that calls serious doubt as to their credibility and motivations. But that's not for a judge to decide. In our system in California, it's a jury trial right, and the jury, and only the jury, determines whether something is true or false as a factual matter. So did something happen? Did something say something? Did an accident occur, or was it intentional? All those are questions of fact, and it's the sole province of a jury to determine whether it's factual or not. Judges determine legal issues. So, you know, does an employer have a duty of care to an employee? Yeah. I mean, that's a legal issue. That the judge would say, yeah, there's an instruction here of what the law is for the jury to apply based on its credibility assessment when it hears from the witnesses. So every time you have a plaintiff and defendant, you have a situation like this. The plaintiff tells a story and the defendant denies it and says, no, that didn't happen. Well, you don't get a case thrown out because it's denied. You get a case, you know, you have to go to the jury to saying like, hey, believe me, no, believe that other person. That's just our system. So it doesn't matter how weak the case is. It doesn't matter how many times they've been exposed as being incredible or lying. They still have a right to go to a jury and saying, this is my story, please believe me. And obviously they're going to be exposed to cross-examination. All this information gets pointed out, and then the jury, you know, potentially says like, yeah, I don't believe these people, and then says, you know, verdict for defendants. So, but again, that we can't do that in our legal system at the Court of Appeal level, certainly, because they don't take any fact finding. We can't do it with a Superior Court judge, because when they have a right to a jury trial, it's not the judge who determines the facts, it's the jury that does it. So again, we're entering a story or looking at a case that's not at trial. It's a pre-trial issue, and it's all procedural things that they're arguing essentially over right now. They have a right to go to a jury. That's what the tentative decision says, and that I expect to be adopted. And I also expect that it will go to a jury trial, and all this information will then come out. That's the time for it to be exposed, not now.
Well, the next thing that they were going through was he called them the undisputed facts. Again, relying on the Robson's case, saying, look, they had the opportunity to take the depositions of anyone they wanted to determine negligent hiring and supervision at MJJ Productions and MJJ Ventures. They're the specific corporations that Safechuck and Robson are going after, but they didn't, which I think is quite telling. Now, he was at pains to really point this out, and I think there was a reason as to why. He was like, look, the purpose of MJJ Productions, created in 1979 by Michael Jackson, was to loan out his personal services as a recording artist. And the purpose of MJJ Ventures, founded in 1991 by Michael Jackson, was to loan out his personal services as a partner of Sony's media company and record label. So the argument that I felt like he was trying to make here is, well, hang on a minute, these companies, they were created for his personal services as a recording artist, his personal services as a partner of Sony and whatnot. They weren't created to babysit Michael Jackson, to watch over his personal relationships and his life, this, that, and the other. Therefore, there was no reasonable expectation for the Robsons or the Safechucks to be like, corporations, you've got a duty of care to make sure that MJ's not doing anything sinister with our kids. How well do you think that argument will hold when it comes to, it sounds like it's going to go to the jury. So do you think that's a strong argument to make in a jury trial?
I do. I mean, it's a very strange situation here where Robson and Safechuck didn't bring their case timely against Michael or his estate. That this was it was not timely brought. Again, I'm trying to still get up to speed on all this stuff, but I believe what happened is that they didn't timely bring their case, but they did have some kind of window opportunity to sue these two entities and decided to make the claim against these entities. And then under this creative theory that the two entities that Michael had created had a legal obligation to protect the individuals here, and that they breached that duty, and therefore they should be held responsible in damages. So that's why it's kind of not going against Michael, it's going against these two entities. And ordinarily, Loan Out Corporation, basically it's just a legal entity formed to, when Michael says, okay, I'm going to contribute my services to this corporation, and the corporation then makes a contract with another entity to basically provide those services. And it's just a way that service providers will do things for tax and legal reasons. Now, and Michael was the sole owner, shareholder of both companies. So, what the attorney was arguing yesterday was just like, look, this is ridiculous. It's not some big operation here that we're talking about. It's basically Michael. It's kind of one and the same. There was no ability by the two entities to actually intervene and tell Michael what to do, because they were kind of, again, one and the same. Now that argument can kind of cut both ways, honestly, but that's what he was basically arguing. And the way that I think Robson and Safechuck overcame that argument is by, again, alleging that these two entities, or one or both entities, had employed them or contracted with them to provide services. And so now that creates a special relationship with these entities, or a direct relationship with these entities where duties would be owed. Now the entities say, no, that never happened. But again, back to my earlier point, saying that it didn't happen doesn't get you out of the case. You have to go to the jury to say it didn't happen. And so their word that it happened is oftentimes enough evidence to create a factual dispute, and to get it to a jury, and that's what they're saying. And so that's again how they kind of overcame it, by saying, number one, we had provided services to these entities. There's some kind of responsibility here that these entities should have because there was a contractual relationship. And then also they're saying that there were other employees of the entities who were aware of certain facts that would give them either direct knowledge that these folks were in harm's way, or a reasonable person would have known that these two minors were in harm's way. And therefore that created a special duty to intervene, protect, warn, do something on their behalf. And again, the two entities dispute all of that. But again, it's going to be the word of Robson and Safechuck against whatever witnesses the entities have to say, no, that didn't happen. And that dispute is a factual dispute that has to go to a jury, like it or not. We can't there's no procedural mechanism to bounce that type of dispute out pre-trial.
Now, the next bit, hang on. No, we don't need that. Sorry. Went on to the wrong button there. The next bit here. So, personally for me, it got a little bit choppy waters, let's put it that way, between the MJ Corporation lawyer and the judge. Kind of felt a little bit antagonistic, I have to admit. I'm going to keep it 100 here. Now, I'm going to go through this very quickly, but quoting the lawyer, he said, now, in what world was MJ, 21-year-old, sole shareholder and sole director of these corporations when they were created, under legal duty not to hire himself? Now, he accuses the judges of saying that if any person is prone to criminal activity, that they have a duty not to hire themselves. Judge Elizabeth Grimes, who was on the panel, denied denied that the court said this and that she doesn't follow the logic. Now, if you don't follow this logic, yeah, I don't think that many people do. The lawyer confirms that's exactly his sentiment as well, that what he claims the judges have said here doesn't make sense. It's like, you know, Tony Rowder saying, well, you know, if he owns it and everything, then why would he have a duty to fire himself? Like, why would he want to do that in the same breath? So, yeah, it kind of went a little bit dodgy, a little bit in the middle, but swiftly moving on, he then turns around and says, look, the claims being made here are completely illogical. And we all know that their claims have been torn apart. Videos on YouTube, Square One, for example, really good one to watch. But he says, look, how can you accuse these corporations of negligent hiring and supervision when no one hired MJ but MJ himself? The only entity, therefore, that could be tried under these allegations of MJ himself, but tough luck, Robson and Safechuck, because he's not here anymore. So the question then becomes, how can Robson and Safechuck go after the MJJ corporations when they didn't hire him in the first place? So, yeah, it's a case of, it seems like it's semantics really in a way, Chris, that they're going on here. That, you know, they're going along the lines of, well, duty of care, duty of care, duty of care, which then drags in these corporations that they have potentially responsibility because they're shouting duty of care, right? Regardless that MJ was the sole owner and leader and all that lot, right?
Yeah, like say that argument cuts both ways, and this came out yesterday when a question, or really a statement probably by one of the justices during the argument, because what the attorney's arguing, Steinsapier, and he's right, is that the plaintiff's theory is that these two entities were negligent, you know, meaning they had a duty to protect and they failed to, you know, take reasonable precautions to protect these two minors, because the entity knew of certain things about Michael and failed to warn or intervene. And so the lawyer for the entities is saying, like, look, I mean, practically speaking, how would that work? I mean, these two entities were formed by Michael. They're fully owned by him. How could he intervene against himself? How could he act on behalf of the entities to fire himself? You know, logically, that just couldn't work. And I think that that's true. But then the comeback is like, well, okay, if they're one and the same, then the entities have knowledge of whatever Michael knows. And so, again, you know, in the demur, we are to take as true everything that was alleged. And so if all these things we have to assume occurred to rule on this motion, then that knowledge that Michael would have in his head is imputed to the entities and would certainly create an obligation now of protection. That's the plaintiff's case. So again, the argument can kind of cut both ways. It is super nuanced and crazy, you know, legal procedure stuff, but that's the problem, because they're trying to the entities are trying to get the case, you know, well, they have it dismissed. They're trying to keep it dismissed based on, you know, this off-ramp here saying no legal duty, but because there are disputed facts of really what the relationship was between Robson and Safechuck and the two entities, and only a jury can determine that. That's why the Court of Appeal, in very simple terms, is saying there's a he said, she said issue kind of thing. There's two people saying different stuff. We as courts, you know, judges or Court of Appeals don't decide those factual issues when there's a right to a jury trial. It's the jury that has to decide that, so it has to go to jury. That's ultimately what's going on.
So the way that I kind of understand it in terms of when you're saying that they're one are the same, in terms of the comeback, I'm going to go really nerdy here, but it takes me back to Star Trek and the Borg. That they're all hive mind, they're all of one mind. And so what one Borg knows, the rest of the population of the Borg know. So I'm kind of like rationalizing it like that. So whatever Michael Jackson did on you, the rest of like the entity of MJJ corporations knew. And that's what I think they're trying to get it on, right?
Yeah, that's it's imputed knowledge, and that's the thing is that when you create a separate legal entity like a corporation, this exists. It's a person in the eyes of the law, and but it can only operate through like a CEO or something like that. So it has to operate through somebody. And then the question becomes, okay, like, well, this is a separate legal entity sitting out here. What duty of care does it have to Robson and Safechuck? And ordinarily, I mean, there's no duty here unless they are involved in a relationship with this person that would create a duty, or they're doing something that's dangerous or that could be dangerous that would cause a duty to occur. So, for example, like if you're driving your car down the road, you have a duty of care to everyone else on the roadway or pedestrians because you're doing something that if you fail to act reasonably or careful with, that you could cause harm to somebody else. So you have a duty of reasonable care to anyone else around you. There was an example given by the lawyer yesterday during oral argument about somebody, struggling in a pool and drowning and a stranger walking by. And legally, that stranger has no duty, as crass or as horrible as it sounds. You have, as a stranger, you have no duty to go and help that drowning person, unless you're in a special relationship, like a lifeguard or a parent, a ward, somebody that you have taken charge. You have a responsibility. You have a relationship with that person that creates a legal duty to save. You can literally just walk by and say, I'm not going to help this person. And so that's the analogy the attorney was making yesterday, was saying, like, look, these two entities exist. They have no duty to Robson and Safechuck because they never employed these people. There was no contract with them. They provided no services with them. They undertook no promise to protect. And so they're just strangers to Robson and Safechuck. And if that's true, then they'll win the case. But Robson and Safechuck are saying, no, it's not true, that they had a special relationship because there were dealings there that created that obligation to go in there and protect them. And again, I know that the entities deny it, but that is classically a dispute of fact. It's a contest of fact that has to go to a jury, not an appellate court and not a superior court judge to resolve.
Now, two terms that I think is going to be mentioned very strongly and very regularly once this goes to trial, because, yeah, after speaking with Chris behind the scenes, I think this is definitely going to go to trial, guys. Fiduciary duty and special relationships. Now, it took me a hot minute to get me head around these terms, admittedly. So, for everyone out there, because like I say, I think these two terms are going to feature very strongly in the upcoming trial. What do they actually mean? What are they in a nutshell? And why is the lawyer turning around and saying you can't conflate the two?
Yeah, so this gets into some language in the tentative decision where they were talking about a special, again, because you have to assume, and that's what's very confusing about these tentatives or Court of Appeal decisions in this setting, is that it's going to start stating stuff like Michael did this or Michael did that, or the corporations or entities had employed these people. And what they're saying, and what they do say at the beginning, is saying, we are not determining that any of this happened. We're not saying that it happened. We're merely recounting or reciting what the allegations are by the plaintiffs. And that's what the plaintiffs are saying. And based on those allegations, does it arise to having a special relationship here between them and the entities such that there is a legal duty to warn, protect, intervene, for their sake. Now, so what the attorney was kind of going after yesterday was just like, there's no fiduciary responsibility. And so in law, there's a fiduciary responsibility for like a bank and a customer. So if you deposit your money with them, they not only have to contractually give you the money back when you demand it, but they have the highest duty of care and honesty to protect your money and not rip you off, not lie to you. With an attorney and a client, there's a fiduciary responsibility that not only we're going to provide great service to them, as a reasonably careful lawyer would do, but we also can't lie to them, we can't cheat them, we can't take advantage of them. So there's certain settings where there's a fiduciary responsibility, a trustee and a beneficiary. So here, I don't see the fiduciary duty. I don't see it going to that level. I think that more the analog is employer-employee relationship based on the allegations. So, if you're employed, the employer has some obligations here to provide a safe workplace. If they know that there's conditions here in the workplace, maybe another co-employee or co-owner, somebody here that is doing bad things to employees, then the employer is responsible. There is a special relationship there. So again, that's the crux of it. That's the allegation. I'm not buying the fiduciary duty part. I don't, and I agree with the Stein-Sapir, on that point.
Yeah, because in the end, to me, in terms of my understanding of it all, he says, look, even if you do accept that MJ's companies had a fiduciary duty, the events that Robson and Safechuck are describing was actually at MJ's home, so it's outside of the organisation's remit as its personal property. It's like, yeah, the bank's got a fiduciary duty to make sure that they look after my money and, make sure they don't rip me off, this, that and the other, but, it doesn't matter in terms of, what political leanings that I've got, a la Nigel Farage, or my UK represents out there will understand that, or, what I do in my own damn home. It's none of their business because it's outside of their remit. So, yeah, but again, these two terms I do think are going to feature heavily in the, I really do think, upcoming trial. So good to introduce you all to those terms. And then the final bit that he tried to argue is, look, they had no idea of their existence in the first place. So arguing that the idea that the Robson family were looking to these corporations for protection for MJ from Michael Jackson, when their only purpose, mind you, was to promote the business of MJ in various ways, isn't supported by the evidence obtained in the Robson case when they're going to deposition and discovery. So in a Robson mother's testimony, she didn't have an idea of who these corporations were. She didn't say that they looked to these companies for protection from Michael Jackson. But now she's claiming that she did look to these companies for protection, but there's no evidence of this whatsoever. So there is a clear contradiction between both sides. One of them's turning around and saying, look, you had no idea that these corporations existed in the first place, therefore you had no reasonable expectation under fiduciary duty or special relationship for these corporations to protect Safechuck and Robson from Michael Jackson in the first place. But Robson's side be like, no, we knew, we asked him, this, that and the other, but there's no evidence to support this. I mean, going through these arguments that the lawyer made as we wind this up, Chris, it seems to be that these are really the arguments that we're going to be expecting when this goes to trial, right?
Yeah, this is a great argument because I got to imagine that, unless there was a paycheck or contract, listing either or both of these entities on there, that why would either individual or their family members have known about these entities at all? So that seems to be more credible to me, that they just wouldn't know about these entities. And if they didn't know that the entities even existed, how could they have been relying upon the entities for protection? So I think that that's a great argument, but it then, again, it comes down to, is there a disputed factual issue over that claim? And so this is an excellent argument for the jury, and I know that it's sold, in getting the cases dismissed. But again, it sounds to me like this Court of Appeal is saying, look, we have the strong preference for trial on the merits. We understand, all these defenses, and they're very good defenses if established, and there's all kinds of problems with plaintiff's case, but they have enough to go to a trial. And that's ultimately, in a very simplistic way, of what I think, is happening here. And then ultimately you go to trial. And because of all these strong defenses and because of all the credibility problems that we know about, it should go to trial, and they should prevail. The defense should prevail on it. But again, that's for a jury to hear, not for a judge to throw out.
Well, as I backstage turn off the presentation for Chris so he can actually see me face. Hi. And oh, hang on a minute. That went a little bit skewy. One moment, guys. Sorry. Oh, technical difficulties. You know how it is sometimes. Hang on, guys. Sorry about this. Oh, I can't believe this has just happened. Nope, not that one. That one. There we go. There we go. Sorry about that, guys. Technical difficulties in the background there. But, you know, as we're now winding this up, you know, the chances are, in terms of our predictions here, this is going to go to trial. How long until we get a decision, like confirmation that that's going to happen?
So they already have the tentative written. They might, make some edits to it based on what they heard at oral argument to kind of clean up some of this language that, was being contested in the tentative, and then issue it, I would guess, about 30-ish days that we should get the opinion. And then what happens is it gets sent back down to the trial court. Now, either side, if it is reversed, the entities can ask the California Supreme Court to get involved, and it's called a petition for review. Those are rarely granted, but who knows? They may take a stab at that and see if they can get review granted by the California Supreme Court to rule on these issues. But if that doesn't happen, we would be looking at next year for the jury trial, and just definitely is going to take that long. It would definitely be in 2024 that there would be a jury trial. Wouldn't happen this year.
So pretty quick then, really, in the grand scheme of things. So we'll probably get a decision, in the next month, maybe? You think it's going to be really quick? Because, I mean, you turned round to me beforehand and you're like, generally speaking, at these type of hearings, the judges have already pretty much made their mind up in terms of what they're going to rule, right?
Well, especially when they've taken the time to do a tentative. So sometimes they're just not clear on it and they need to hear from the lawyers. Here it was like, they didn't need to hear from the lawyers, really. They had already made up their mind. I mean, they said they didn't, but I think they did. And, but we'll see. Like I say, about 30 days out, we'll get the final opinion by the California Court of Appeal. The two entities, the defendants can ask the California Supreme Court to review that. But, like I say, we got to see how that progression works. But this is a very slow process. And so when it eventually does get sent back down to the Superior Court for trial, that's also a long process. We got to make sure all what we call discovery is completed. So there may be additional depositions that need to be taken or records that need to be obtained. We got to fight over the admissibility of that evidence. We got to pick a jury and then get in there and start it. So that's easily a year out from now.
Well, with that being said, we're going to wind it up here. Everyone that's watching live, stay exactly where you are. But if you're watching on the replay, first and foremost, if you haven't done so already, why haven't you? Make sure you subscribe to Popcorn Planet. Click that notification bell to all. Like this video. Comment down below your opinion, conspiracy theory, whatever. Do you think MJ is innocent or not? Let us know. And go one step further and join today. Become a Popcorn Planeteer for as little as $5.99 a month and get exclusive additional content from the man himself, Andy Signore. Today's been actually a little bit of a Steph Chris takeover on Popcorn Planet, to be fair. And it's been so much fun. So thank you so much for taking the time out today for doing this with me. Really appreciate it, hun. Do make sure you're following Chris on Twitter at @CA_divorce. Again, those on the live stream, stay exactly where you are. But vote for those on the replay. There's some videos that are showing up right now that you might want to watch. Clickety click, clickety click.